tactics that we were dealing with that made this case more time consuming. We also had to overcome and defeat the plaintiff's broad overarching discovery request, which the court also agreed with us at that time was improper for the phase of the litigation that we were in. And we bring these issues up now because plaintiffs, dilatory and sometimes contumacious tactics referenced in the attorney declarations and here on the slide, they help explain the amount of attorney time expended in this case. And so just a few more points to make here. We are also requesting our contingent appellate fees, which are also mandatory under the statute, the fee shifting. And plaintiffs have certainly indicated their intent to appeal this matter as they have filed a notice of appeal. Whether it's premature or not is a different issue, but they've certainly demonstrated their intent to appeal your Honor's orders. And so on the contingent appellate fees issue, courts, rather than the lodestar method, rely just on attorney expert testimony in awarding those fees. The attorney declarants here, Mr. Noche, Ms. Kushner, and Mr. Zorn, have testified that their respective firms will handle the appeal of this matter, and that based on their experience, they've estimated the reasonable appellate attorney's fees, which comprise research, brief writing, preparation for oral argument, and all the other necessary tasks for litigating an appeal in the state of Texas. And they arrived at these figures based on their experience litigating appeals, including in the state of Texas. And so we referenced those estimates in our papers and in the attorney declarations and in the proposed order. So I won't list them out here now. But
might as well just say them. I'm feeling like your fees are pretty high here, Ms. Curry, honestly. So you might as well tell me, what is it that you're seeking on appeal? Go ahead.
Sure. So
give me the bad news.
Sure. The USONA Pro Mega defendants, Mr. Noche estimates that a cost of defending an appeal in the Court of Appeals would cost $80,000 plus $7,500 in costs for Munch-Hart. Petition for cert to the Supreme Court would cost $30,000. And then merits briefing and argument in the Supreme Court would be another $60,000 plus $7,500 in costs. Ms. Kushner, whose firm would assist in the appeal of the matter, being the resident expert on defending the research institutions, has testified that defending an appeal in the Court of Appeals would cost via Von Briesen $40,000. Petition for cert $20,000, and merits briefing in the Supreme Court $30,000. And then Yetter Coleman, which Mr. Rossum I'm sure will speak more about if necessary. Mr. Zorn has testified that the defending the appeal in the Court of Appeals would cost $60,150. A cert petition would cost $32,000, and a merits briefing and argument in the Supreme Court would cost $92,000.
Wow. I'll tell you, we've had a Texas Citizens Participation Act case, which honestly seemed more complex than this one. The fees were a lot lower and the attorneys were fancier, but that's just my view. There's a saying, what is it? Pigs get fat, hogs get slaughtered. This is a lot of money, folks. I'm not particularly happy with what you all are coming to me on. We've tried to do this as efficiently as possible for you. And I feel like it's an overreach, taking advantage. So that's just me, but I haven't ruled on it yet. But I'm just telling you, you might want to sharpen those pencils a bit. All right, go ahead, Ms. Curry.
So we've also got nominal costs that were incurred via the law firms as shown on the slide. I am wrapping up, and just to sum up, the defendants are requesting the reasonable and necessary fees that they've incurred and the costs in defending this action, which the statute does require. The defendants have put forth competent declarations supported by true and correct fee statements, and the plaintiffs have filed no opposition, let alone controverting evidence. And so we would submit that the court should award the lodestar fee.
All right. Thank you, Ms. Curry. All right, Mr. Kamek, you didn't file a response. What's up with that deal?
Your Honor, there was kind of some back and forth where originally I was not even CC'd on some of the hearings. So, a lot of what they're claiming that they had charges for are completely unrelated to the anti-SLAPP and when they were dealing with the pro se plaintiff. Uh,
Are we with the court reporter? We are. So you need to slow down so my court reporter can write down everything you're saying. Why
understand.
don't you have a response on file? That's what I'm asking you.
I understand, Your Honor. So the reality is I was not timely notified of the hearing by opposing counsel. I was in trial and out of town for the death of my grandmother. So those were two things that had happened when they finally decided to notice me, and they did not. They sent it to the client as opposed to me. So I do apologize for not having a response on file, but I do have
Who
trial.
wants to stop? Who wants to speak to that? He's saying he didn't get notice.
I eventually did.
Okay, when did you get notice?
I can pull that up, Your Honor. But they essentially said, "Well, we've sent it to your client, so why would we need to include you?" And I
When
had,
did you get notice? That's my question. And
yes, Your Honor.
I'm really not trying to be difficult. It's just these big firms whom have really lost my trust, quite honestly, with this very grabby fee structure. They should know better. But I don't have anything else in the file because you didn't file anything. So when did you receive notice, sir?
And Your Honor, that's what
When?
I'm trying to look that up, Your Honor. It looks like it might have been Friday the 4th.
Okay, so we are now here on October the 17th. So there
That
has been time for you to file some sort of response to this, and you didn't.
that's correct, Your Honor.
All right, I don't know what we do about that problem. All right, finish your argument as best you can without a response on file.
I mean, I think first and foremost, there's some common law claims that are not subject to the anti-SLAPP that they're just not entitled to the fees related to. There's a lot of their work is cumulative. I do not think their hourly rate is reasonable. I mean, I've tried 2 week trials and not had fee rates at this rate. I think there's some overbilling and duplicative. And so I don't think they can say, hey, look, we had a fight with the pro se plaintiff over this, or we're alleging dilatory tactics, or we had to get a protective order, or do all these other matters unrelated to the anti-SLAPP, where there's no causal connection between the work done and the anti-SLAPP motion itself, and claim that they in fact can charge for that. I also, again, I don't think there's a mandatory fee award for things that are common law claims, such as the fraud claims he brought, that wouldn't have been subject to the anti-SLAPP
All
motion.
right, let me hear from you, Miss Curry, on the fraud claims. What's up with that? So he's saying, look, you all have billed for fraud, but those aren't anti-SLAPP. So why should I give you money for that? Tell me your response, please.
Your Honor, we moved for dismissal and received dismissal on all claims in the petition under the anti-SLAPP statute. And when we were before you arguing the TCPA motion over the summer, we did not hear any argument, nor was there any in the papers, that some of these claims weren't subject to the TCPA. Fact is that the case was dismissed pursuant to TCPA motions, and that included all claims and all with prejudice.
All right, folks, I don't know what to do about you. I really don't. I mean, the Church of the Sacred Synthesis may not be everybody's cup of tea, but they are apparently some sort of church. So, and they're folks who've shown up in my courtroom, and I find them to be sincere. So what you're asking me to do is to award buku appellate fees and what 232,000 some odd dollars in fees against these people. And we got no response on file from Mr. Kamek. So yeah, although he's had notice since October the 4th. So I'm not prepared to rule on this right now. I'm going to have to give this some thought. But folks, I am not happy. Defense firms, I feel like you're being grabby. Mr. Kamek, there's no excuse for you not having filed a response here. So
Understood.
with that, I'm going to let you all go for the day, but I'm telling you, I have seen these people in my courtroom with this Church of the Sacred Synthesis, and I do find them to be sincere. Now, without a response on file, it does tie my hands just a bit, Mr. Kamek. But wow, the thing is, folks, you come back through my court all the time. I'm going to see you again. I'm going to see these firms again. And I'm going to remember this, that we had, some folks, they may not be everybody's cup of tea. We may not all believe what they believe, but they are authentic in their belief. And you're going to come after them with this degree of fees? Come on. I don't, I'm not understanding where you're coming from on that deal. Okay. All right. I need you all to please be excused. I'm going to have to give this some thought before I rule. Thank you. You may be excused for the day. Let's go to the next case.